Hello, everybody. What's going on? Sorry about the wait. I had to turn on slow mode because this chat was on fire. What's going on, everybody? You know who I am. My name is Nate, the lawyer, and we're about to get in it in like 2 seconds. So just sit tight, and we are about to jump into this. Just taking care of three little things. Here we go. And we are off to the races. Good morning, everybody. Welcome to the show. My name is Nate, lawyer, YouTuber. Looks good. Looks good. The lamp is back in all of its glory. It's funny, I missed this lamp. It was acting up the other day, but lamp is back. It's doing well today. So yeah, lamp gets back in a fit. How's everybody doing this morning? Secret Squirrel, hey, what's going on? How's your Flying Monkey? All my favorite people are here. What's going on? We've had some exciting developments in the non-sex show starting to happen. It's interesting. Just for everyone to know what's coming up soon. I will be. Oh, where's the mask? You'll go. So there's just quick update. I'm cutting the Cardi B video today. Cardi B actually tried to get her case dismissed on a speedy trial motion. So we're going to be checking out that. So I'm just going to give everybody an update in the case. And it's interesting. The news media hasn't updated Cardi B's case, which just happened. So it's going to be an interesting little video I put together for you guys. So I'm going to obviously release it to members and Patreons because they get it. So they'll get it a couple of days before you guys get to see it, but it's going to be good. Hey, what's going on? $5 super chat from Gene Wilson. Hey, good morning. Looking forward to this. Hey, I'm glad. Thanks for the $5 super chat. I appreciate it. So how is everybody out there doing? I know we have a lot to go over today because Kyle's attorney has come out and boom, she's hitting them hard. So we get to see what happened. Again, I turned on slow mode for the chat because it was fire before I hit it came in. I was like, damn, I can't even see anything. So we're going to see. Again, me and my baby spoon. So it's a baby spoon. Yeah. But I love it because it's just so perfect for this. So you guys have been probably tired of me just wish-washing and saying whatever. So let's get into the document. So first, where are we at? So if you've never heard anything about the non-sex show, I know most of the people in the chat probably have heard, but there may be one or two people out there who don't know what the hell I'm talking about, don't know what the non-sex show is. So I'm just going to give you a quick summary. The non-sex show was a show here on YouTube and had two hosts. One's name was Kyle Curtis and Steve Mcrae. Now, they had a pretty good show. They got up to about almost 30,000 subscribers. Steve became toxic for the show. For instance, one of their biggest stars like Matt Delahanty, Aaron Raw refused to appear on the show with Steve Mcrae because Steve became so toxic. You know, Steve eventually even got a harassment restraining order against a woman in Minnesota. So, you know, Steve became very toxic for the show. So Kyle removed Steve from the show, essentially fired him from the show. Steve then claimed that he was a 50-50 partner, which most people, I think, would have agreed with in the past. So after Steve was kicked off the show, Kyle said that he was going to give him some funds. There was a whole big fallout, and we thought it was over. Steve essentially sued Kyle in North Carolina. So Steve got a lawyer and sued Kyle in North Carolina, and he had a benefactor who happened to be funding the lawsuit. So Steve did his thing. He filed the lawsuit. He served Kyle and got a default judgment. Now, obviously, as you know, a default judgment doesn't say you won on the merits, right? Default judgment is just like winning a default basketball game, right? So essentially, because Kyle didn't show up, Steve was awarded everything he was asking for. But there was a problem. And that problem was Kyle served properly? So Steve was cheering that he had won. We all thought he had won. Then Kyle came back and said, well, hold on. I never got these papers, right? I never got these papers. Oops. Let me see. What's it say? Nate, read super chat. LOL. Oh, there's super chats. I'm sorry. I haven't seen one. Good. I see this one. Good morning. Let me go back to, maybe it's on the YouTube stream. Super chats. And I missed something. You got me scared here. I haven't seen any. No super chats. I got one. Is there another one I'm missing? If I missed somebody else's super chat. Oh, yes, I have missed one. Start streaming while I'm asleep. Oh, thank you, Nervy. I'm sorry. I missed your super chat. Yeah, but I got two. I am reading the super chats, so sorry about that. But yeah, I've only missed one. Oof, you scared me up now. Don't scare me. But yeah, I will be reading all super chats, so I'd appreciate and thank you for your support. Thank you for all my members. Thank you for all the Patreons. Listen, thank you guys for your support. It really, really helps, and it helps me. It frees me to do this content the way I want. Hopefully, the law practice is actually going well too. But now, this will allow me to really do a deep dive, because a lot of these things, when you're trying to do these online legal stuff, you really want to get it right. So it does take a lot of research, and I'm reading cases in North Carolina, for instance. So back to the non-sex story. So we're at the point now where if Steve didn't serve Kyle the papers correctly, Steve is more or less, the case is going to be restarted, right? Well, Jameson, if just type it here again. Tag me, type it here again, and I'll read it. Sorry, it just didn't show up. Cool, Jameson. Yeah, I know you super chat all the time. Just send it again. I got you. So we are now at the point where we're going to see Kyle and Steve's response to that, and Steve's lawyer. So let me go back. So Kyle didn't have a lawyer. Kyle just was doing this all himself, right? He turned in a motion to set aside the default judgment. It was a little wonky. Like he put a typo in there, and Steve's attorney was jumping all on that, right? Kyle, it just got crazy. So then the community came together and gave Kyle $5,000 to get an attorney. The community gave Kyle $5,000 to get an attorney to fight Steve, which was remarkable in of itself. I can't get a couple of super chats. He's getting $5,000 to fight a lawsuit, which to be honest with you, it's fantastic. It shows you how much the community didn't want to see this thing go unfairly. So Kyle got an attorney, and now Kyle's attorney has revised Kyle's original motion to set aside the default judgment, and we are going to look at that right now. But before we get into that, first I want to go back to Steve's arguments. Let's go to Steve's arguments on why Kyle was served correctly. Now, before we get into that, let's talk about the facts. There are facts that we should all be aware of. Fact number one: the summons and complaint were sent to Kyle's old address. They were sent to Kyle's mom's house. That's fact one. So they weren't sent to Kyle's address. They were sent to Kyle's past address. That's a fact. Fact number two: Kyle didn't sign for it. It was his mom that signed for it. That's the second fact that both sides agree on. These are facts that are not in dispute. It went to Kyle's old address, which was his mom's address, and his mom signed for it. Those are two facts that are not in dispute. The third fact is that Kyle had actually moved. Kyle moved. So since Kyle had moved, that is another fact that we have to also establish. Kyle had moved before he was served at his mom's house, or before they sent the documents to his mom's house. Here we go. Jameson, Nate is it virophobic to wear a mask to stop the spread. LOL, stay healthy. Yes. Thanks so much, Jameson. Thanks for the $5 super chat. So these facts are not in dispute, right? These facts are not in dispute. So with these facts, it comes to, the last fact is that the summons and complaint was mailed to Kyle. It wasn't, usually you can have service be achieved through personal service. Somebody actually hands you documents. That didn't happen here. They were mailed through certified mail to Kyle's old address, his mom's address. So those are the things that we have to think about when we're doing this. I will get you a Trump 2020 mask if you want, and I will wear it. You get me a Trump 2020 mask, I will wear it. And I'll record myself walking around Harlem wearing that mask. It'll be fun. Get me that mask and I will wear it. Thank you, Jameson. I doubt you'll get it to me, but get me that mask and I will wear it. All right. So let us go over. So now before they ado, let's go over to see what Steve. Now, let's first start with Steve's argument that Kyle was served correctly. We're going to hear two clips, both from Steve, explaining why he believes Kyle was served correctly and why this is all nonsense. So, in preparation for that, let me go to this clip. I believe this is the one. Yes. Sorry, let me do this one more time. Because I didn't hear share audio. Here we go. And we were going to hear Steve's explanation on why he believed Kyle was served correctly. Here we go.
Oh, yes. He's been, well, we're going to get into that because as people know, he tried to file this motion to dismiss for improper service. Absolute nonsense. It is pure gamesmanship. We have overwhelming evidence that he was served properly. The address that he was served from, which was his a family member's address, which we knew was an old address. I knew that we knew that was an old address, but that's fine. He had no forwarding information on it, and an adult signed for it. In North Carolina, whoever's helping him does not know North Carolina law, I guess, whatever. But in North Carolina, he was properly served because it was sent to a known address and an adult signed for it. That's the only legal requirement.
Can we say which adult signed for it?
I'd rather not.
Okay.
I think
So just to be clear, Steve here is saying exactly what I just said, the facts that are not in dispute. He sent it to an old address, an adult signed for it, and he's saying that is enough under North Carolina law that you were served properly with a lawsuit. Now, obviously, that's hogwash, right? That's ridiculous, right? If you could just send to summons a complaint to any old address and then say that the person was properly served, that would, people get default judgments all the time, right? I can send, lawsuits to Tom Cruise's past old address for $1 billion and he'll never get it, and then say, well, there was an adult there that signed for it. Hell, if I lived in, let's say Tom Cruise lived in my address, right? This was his last address, which is not, obviously, but let's say this was his last address. I could then go to court, file a lawsuit against Tom Cruise, right? Have my wife sign my wife sign for it, and then get a default judgment for $1 million against Tom Cruise because this was his last known address and an adult signed for it. This is idiotic, right? This is not the law in North Carolina, but Steve thinks it is. So that is his argument. Let me read this super chat from Who's Your Buddy. Thank you, Hoosier. It is too expensive to help a professional criminal with lawsuits. Only real fans will get it. Thank you, Hoosier Buddy. That's true. Only real fans will get it. It's a little too expensive, but the community came out for Kyle. Thank you for the $5 super chat, and they hooked them up. Good morning, everyone, and good morning. Good morning. I see everybody saying good morning. Good morning. So now we know what Steve is saying, right? Steve is saying he sent it to an old address. He's an expert. He's from California, but he's an expert in North Carolina law. And guess what? He can send it to an old address, an adult signed for it, and he is good. Now in this next clip, they're going to just go a little further and give us a little bit more explanation on why they believe. Again, they're going to tell us why they believe that Kyle was served properly. So listen to their reasoning, because that's going to be the most important point here. Listening to their reasoning on why they believe Kyle was served properly. All right, there we go.
Lawyers like, this is pure gamesmanship. He was served properly. We know where he was served, which again we knew was a previous address. He already said he had moved, or he was living with his boyfriend or something like that. But it was a proper address. It was signed by an adult. It was a legal serve. Simple as that. And he knew about it. And the fact that he knew about it, that's all that matters. He had mens rea of the service, because he admitted it in multiple videos, like days after he admitted that he was served. So you can't go back later and say, "Oh, it wasn't served properly." He knew he was served. He said, "Yes, I have papers." And even in the screenshot I said, he gets things from the court. right? So, I mean, there's just no standing to have it vacated on that. There's no standing that he didn't get served properly. It's called gamesmanship in legal terms, and judges hate it. Okay, so so the podcast, like I said, I have the podcast now. I have the Fireside Podcast in my name.
Sorry, I was muted. So in this clip, Kyle says plainly, they're saying that Kyle said he was served. They're also saying that Kyle said that he got the papers and that it doesn't matter if he was served properly or not. And it doesn't matter if he was served properly or not, because the fact that he got the papers and he knew he was in the lawsuit, that overcomes everything, right? All he is doing it. No, thank you. I corrected the problem. Thank you for letting me know I was muted. I muted so you guys can hear it. Thank you guys. But you guys can hear me now, right? I'm assuming. Make sure. Yes. All right. So that's what's been happening with Kyle. Why do you have a goddamn spoon in your coffee? Stupid whore energy. That's my spoon. This is my thing. If you come to watch Eastern, you're going to see a baby spoon in my coffee. It's my vice. Thank you, Stupid whore energy, for $5 super chat. And thank you for letting me know I was muted. But you guys can hear me now, right? Yeah, everybody can hear me. Jameson trying to silence the black man. That's true, Jameson. And thanks for the $5 super chat, Secret Squirrel. I appreciate it. Let me know. Technical difficulties. So we now know the arguments, right? We know the this is not complex, right? Steve is saying, well, hey, number one, we sent it to a wrong address. His mom signed for it. We know. We also know that Kyle didn't sign for it, but he eventually got it, right? And we have a clip that says that he was served. So that should be more than enough to overcome this stupidity, as they call it, that Kyle may have not been served properly. Here we go. We had a $4.99 super chat from Dana McWhite. The hill wants to die on. This hill Steve wants to die on isn't worth it. Just start the case over. It's not a big deal. His fights over the most petty crap. Yeah, it is. But again, it's a legal issue now, so the judge will decide. Thank you for the $5 super chat, Dana McWhite. I don't know why I read that so poorly, because I got so many things up. Let me close some of this stuff. All right. So now we've heard Steve's argument. Now, before I move to Kyle's attorney's filing, let's look at, there are a couple of pieces in Steve's original response that I want you guys to look at, which I think is very interesting too. Let me go share that piece of the screen. Now, this was Steve Mcrae's original filing in opposition to the motion to set aside a default judgment, right? This was Steve's original response, because this is him saying, and they make some of the same arguments that Steve has just made, right? There's one piece in here that I want to really point you guys' attention to. So here, they kind of admit that, yeah, he was living at the unknown address. But the first thing they say is that Kyle turned in some unsworn items as admissible hearsay. Now, Kyle turned in two documents, two affidavits that weren't notarized. So they're saying here that because they weren't notarized, they are inadmissible hearsay and you can't be used. So that's something we also have to think about too. So, for instance, his mom's affidavit. Steve and his attorney said, well, you can't use those anyway because it's inadmissible hearsay. So that's one thing that we'd have to see. The second thing is that they're also saying is that here, let's see. They're also saying here the defendant had actual notice of the lawsuit and has failed to rebut the presumption. So they're saying that because Kyle had actual notice of the lawsuit, that this should also be good. And then they try to make a legal argument for that. And then the last thing, and then they conclude that because he had actual notice and that the evidence that he provided wasn't notarized, right? It's inadmissible hearsay, then the court should more or less throw out his motion to set aside the default judgment because the evidence wasn't good and he had actual notice of the lawsuit. So his legal arguments and his what he's been saying on stream all line up. They're saying the same thing. So let's go to Kyle's filing and see if the lawyer fixed some of these problems and how we're going to move forward from here. So without any further ado, let's check this out. So this was filed yesterday in the North Carolina court, and we will go through it together. First, let's go through the exhibits because now the reason why I want to go through the exhibits today first is because the exhibits will kind of give us an understanding of what the lawyer is going to be saying in the document, right? It gives us instead of having to go back and forth looking at the exhibits, then looking back at the document, we can kind of look to see what's already in here and then reference them back in our mind when we read through the actual motion. So let's go through the exhibits and see what Kyle's attorney what is put forth in the exhibits. So just going here. So this is the affidavit of Kyle Curtis. So Kyle has now made a new affidavit. Let's read what it says. Kyle Curtis, being duly sworn, states as follows. He states his name. He's a citizen. He gives his address. Now, before people go crazy, Kyle has already given me permission to that when I do these type of videos that I can show the address. So it is okay. I was going to black these things out, but Kyle previously gave me permission that whenever I do this, I could use this address since it's already out here and it's part of the case. So I do have Kyle's permission. Thank you, Kyle, for doing that. I appreciate it. And for people who don't know, YouTube's new terms of service, even if your address or any identifiable information, individually identifiable information, even if it's in a public document, you still can't put it on a video on YouTube because it's YouTube is now considering that doxing, even though it's in a public document. So, for those creators out there, you have to be careful because they're becoming more strict on that. So that's the reason why I actually got permission from Kyle, just to make sure I was in compliance with YouTube's terms of service. Back to the document. So Kyle's a citizen. He gives his address, the address he's living at. It says that he's been living there since July 16th, 2019. On February 5th, I executed an affidavit that was filed in this case on February 12th, 2020. Now, that affidavit contains a typo. Now, why is this important? Well, remember, Steve's attorney just a couple of days ago, I think last week or was it the week before, put in an affidavit claiming that typo, that Kyle made a typo, claiming that typo was somehow proving that Kyle was lying about his address because Kyle made a typo in his previous affidavit, and that address didn't exist, right? That address just did not exist. So Steve's attorney sent the affidavit to the court saying, hey, Kyle is more or less lying. This affidavit doesn't exist. Now, they didn't claim Kyle was lying in the affidavit, but that's essentially what they were saying. Kyle was lying because this address didn't exist. But if you look through the document, it was just a typo in the document. And all the other addresses in the document were the correct address. So it was a mistake. It was a typo. So it seems like Kyle is addressing that with this new affidavit that he filed yesterday. So the affidavit contains a typo. It states that my street address was 2435, but it's actually 2543. Simple typo, right? My correct address. And they put appears 7 times in the document accompanying the affidavit. So he's saying, that the correct address appeared 7 times in the document, and this, the wrong address appeared once in the document. So, it was an obvious typo. So then he's attached the documents to the affidavit showing that he resides at the correct address. So all the documents that he attached to it, all this evidence showed that he lived in the documents. Now he's telling us what those documents are. Those documents include his lease from the proper address that he started in July 15th, a credit card statement, a tax document. And as of today, he has never been served with the complaint nor any other filings in his address at the address of 2543. Now, why is this important? This means that all of the documents that Kyle is saying, all of the documents that Steve sent, he's never actually received it properly. He's always received them kind of as third party. So everything that Steve has sent in this case has been sent to the wrong address, right? Either to his mom's address, which he didn't live for, and some other address. That is what Kyle is now claiming, which makes sense because even Steve's attorney, he got the receipt saying it was, sent to the wrong address. So moving forward. So Kyle says, I have reviewed the affidavit of service of process that Steve Mcrae filed with his attorneys on October 2nd, 2019. The affidavit shows the complaint filed, blah, 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 right? Sent to his mom's address. So he says, I did not reside there, right? On that date, on August 30th. So Kyle moved in July. And on August 30th, when the document was sent to his old address, he didn't live there. So that's what he's saying. And, as of this day, and he's attesting to this as of this day. Signature block here is Kyle Curtis's signature. Here's the notary. So now this is tight. This thing now is tight, tightened up, right? This is not hearsay anymore. It is now, you have a notary sign for it. It is good, right? So now that kills Steve's argument in the past that, hey, it wasn't notarized, right? So it's inadmissible hearsay. No, it's notarized as of now. So that has killed that argument. Exhibit A. Let's see what the exhibit is. So here is Kyle's the original affidavit from when he first did this with the error. Here's the error, 2435. So he's saying, yeah, here it is. This is the error. But here is all of the other evidence that accompanied it. There's rental agreement, month-to-month rental agreement with Benjamin Potts, signed. So now he has the rental agreement. He's put that into evidence. Exhibit C. This is his bank statement. His bank statement is from August 1st to August 30th. Now remember, so if he was served on August 31st, this bank statement says it was going to this separate address, right? So obviously it's saying Kyle didn't live at the address the documents were sent to. Now let's look at, so he has 2 pages of these bank documents. He has one for that and then for the next month, for November, showing that he still lived there continuously for that time. Exhibit D is the tax return. He has the taxpayer's taxpayer ID number, and he has the new address here. So you see the 1099 form. So Kyle has now presented tax documents, all that stuff, and saying, I didn't live here. Here it is. So that's the first exhibit Kyle has. I made a typo. It's all here. Now it's all signed up. So now let's go. They presented another exhibit. They have an affidavit from the mom. Now, remember, the big problem with the mom's affidavit before was that it was hearsay because it wasn't notarized, right? It wasn't attested to. So let's see if they fix that problem. Jameson, Jameson, does North Carolina have an unsworn declaration? It seems like North Carolina allows these declarations to be in court as long as you attest to them under penalty of perjury through this process. But again, that's North Carolina. I'm not sure. So, but it seems to work that way because right now everything that's being put in, like for instance, Steve's verified complaint, he didn't go into court. He actually had it notarized and put in. So it seems like that's they're allowing that to overcome the hearsay component here for the filing. $20 from Nobody. Thank you, Nobody. I'm glad you're enjoying the stream. Thank you for the $20 super chat. Trust me, I really appreciate the support. Thank you. All right, so we've seen the first exhibit. Now let's look at the second exhibit. Because that matters. Exhibit number 2. Here we go. So this is the second exhibit that accompanying Kyle's motion to set aside the default judgment. So let's check this out. This starts with, again, this is a affidavit from Kyle Curtis. All right, so this is the one we just looked at. I'm looking for the next one. Sorry. Oops. There it is. Part 2. Exhibit 2. All right, so this is, make sure I'm putting the right thing on there. Yes, this is the affidavit from Kyle's mom. Check this out. Thanks again, Nobody. This is an affidavit from Kyle's mom. So remember, so it has the caption of the case, and here I'm going to have to blow this up because it's so small. This says, I, Susan Curtis, being duly sworn. My name is Susan Curtis. She's over the age of 18, competent to provide this affidavit, a citizen. She tells you where she lives. My son, Kyle Curtis, is named as a defendant above the caption of the lawsuit. On August 30th, a summons and complaint addressed to Kyle Curtis were delivered by certified mail to my residence, right? I signed the certified mail slip. So no disagreement. when I signed the certified mail slip on Carl Curtis was no longer residing at that address since July 16th, 2019. Kyle resided at, gives the new address as of that date. Kyle still resides at this new address, and she has signed herself today. Now, remember, Steve's big issue was that this was hearsay because this was not notarized, but as you can see, this was sworn before the notary. So now we have overcome that notarization piece. So now this is no longer hearsay. This is now sworn testimony. Boom. So Steve's biggest objections have been resolved, right? This was hearsay because it was not notarized. Now it is. So what do we have? We have Kyle's mom saying, hey, he didn't live here under penalty of perjury. We have all the documents. We got bank statements. We got tax documents. We got a lease agreement. So there is no question that Kyle did not live there, right? There's no question that Kyle didn't live there. So now we've seen the evidence. Now let's look at the legal arguments. Here we go. Motion to set aside the default judgment. And here we go. So again, this is Kyle's motion. This is now Kyle's renewed motion, the attorney. So this is now at the beginning, she just gives the law pursuant to rule blah, 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 to allow her to make this. So here's the introduction. This case concerns ownership rights of a YouTube channel, which we all know. That's true, right? It concerns ownership rights of a YouTube channel. The non sequitur show. Hold on, let me make sure I pull this up so I can see. Good. All right. So Steve Mcrae filed a 7-count complaint against Kyle Curtis over the dispute. However, Mr. Mcrae, however, served the summons and complaint by certified mail to an address where Mr. Curtis no longer resided. So that is not in question. That's true, right? Steven says that. Based on service to that address, Mr. Mcrae obtained a partial default judgment. These are facts, right? These are facts. He sent it to the wrong. He sent it to an address that Kyle no longer, and he got a default judgment based on that fact. Because Mr. Curtis has not properly been served with a complaint in the lawsuit, the partial default judgment is void under Rule 60b-4. And that's true. The court, if Kyle was not served properly, the court does not have jurisdiction over Kyle Curtis. They just do not, right? That is a clear rule of law. You got to serve the defendant properly, or the court cannot make any type of ruling. So this is the rule. She's citing the relevant law and saying this is why it's over, right? Very clear, very concise, and you don't get into a whole bunch of mumble jumble. If you look at Steve's motion, it gets into Steve's attorney. And this, let me say this. In law, when you're practicing law, if you have the facts on your side, you argue the facts. If you have the law on your side, you argue the law. And that's what you're seeing here. Steve's attorney have the facts on his side. Kyle knew about the lawsuit, right? He had actual notice. You know, he this was it wasn't like this was a secret. That's what they have facts. Those are great facts for Kyle, but those are great facts for Steve. I said great facts. Those are great facts for Steve. But Kyle has the law on his side. Assuming this is that, well, yes, even though he knew about the lawsuit, it didn't go to his actual address. So let's continue. Oops, put this up here. And just so, because I'm reading this document, if you guys do, if there are a lot of things going on in the chat. The chat is like boom, 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 boom. So if you do have a pressing question, just throw me if you throw me a super chat, I can see it. You don't have to throw a super chat for me to see the question. You can tag me, but it's just going to be, I don't want people to think that I am ignoring them. It's just super chats. They pop up in such a way where I can just boom, 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 boom. So, and if you don't have a super chat and you want to leave a comment later or just, send me something, that's more than fine too. But just so people don't think I'm ignoring them. It's not that I'm ignoring you. It's that it's hard for me to just scroll up and down through the chat, especially when I'm doing this. So just, but if you do have a pressing question, if you super chat it, I will get to it. I promise. All right. So Now back to Kyle's attorneys. All right, so looking at this, it says the relevant background information. So we go through it. On August 23rd, Steve initiated this action, and 7 days later, the summons and complaint were delivered by certified mail to Kyle's mom's address, right? The residence of Susan Curtis. And she says she attached both Kyle's affidavit and Susan Curtis's affidavit to show that, hey, this is true. So she's backing up her facts with she's corroborating those facts. Here it is. Let's continue. When the summons and complaint were delivered to Mr. Curtis's residence in Pleasant Garden, but Miss Curtis's residence on April 30th, Kyle no longer lived at that address, right? So again, these are facts, and here it is. See affidavit from Kyle, see affidavit from my mom. He wasn't living there. Then they give Kyle's current address. He lived here, and to date, again, here it is, to date, Mr. Curtis has never been served at his address, right? At the address that he lives at now with anything. And that makes sense because even if you look through all the stuff for Kyle and for the rest of them, he has actually never been served any of this. And Kyle's attorney, remember, he was sending it to a wrong address, to the address that did not exist. Here's a $5 super chat from MD. If the partial judgment is overturned, does DM have grounds for malpractice based on improper service? Well, no, because this kind of happens all the time, and it really would depend on the facts. Did Steve tell the attorney, hey, this is an old address? Did the attorney say, okay, old address is good? That's going to be heavily fact dependent. So, I wouldn't be able to answer that question either way, but I think it's a good question, and we'll see, because hey, they may come back and say, hey, we told him it was the wrong address, and the lawyer, we'd expect would tell us that, hey, you can't send it to an old address. We have to get this guy personally served because they may get kicked back. So again, we just don't know. I don't know what their conversation was. He could have, for all we know, Steve could have said, well, hey, this is Kyle's, current address or his business address. And the lawyer could have, there's a lot going on there. So I would be, if I was, if I was the plaintiff on this case, I would be looking for a redo on the hookup. You know what I'm saying? It's like, yo, you got me in default judgment, but you got to, you can't be charging me now again because you just messed up. You know what I'm saying? I told you, if Steve told the lawyers an old address and this comes back down, then I think the lawyer can't just say, all right, well, pay me again to do all this again. And the lawyer messed up. So it really depends on who messed up. If the lawyer messed up or did Kyle mess up? That's what we're really talking about. Who messed up here? If you're talking going that route. But thanks for the question. Thanks for the super chat. All right. So let's get back. So Mr. Curtis, so right now, this lawyer is hitting him hard, right? Very professional. Forget, F all the drama, right? Let's just keep it professional. To this date, he's never been served at the proper North Carolina address. Affidavit of Kyle Curtis, right? So now, Kyle Curtis, so Mr. Mcrae moved for an entry of default judgment, and the court, the order for entry was the next day. So she's laying it out. This is just the history of what happened. Mcrae then filed a motion for default judgment on October 19th and a renewed motion on November 14th. Now, remember, that was because Mcrae his affidavit that he turned in wasn't notarized. So remember, they had to get it notarized because it was inadmissible hearsay, and that's what happened when he first turned it in, and then he couldn't turn it back in. So Steve actually had this same problem when he was trying to get his default judgment. When Steve was trying to get his default judgment, he actually had the same problem. He turned in an affidavit that wasn't notarized, so it was technically hearsay, and the court said, well, you got to get it notarized, and then he got it notarized, and they were able to enter the default judgment against Kyle. $5 super chat. Can you look at Trump number 4 executive order reduced to? Oh yeah, no, definitely. I'll check it out. Thanks for that. Thank you, Patrick Booty. I will definitely check it out. I have so many things on the list right now that it's just getting a little hectic, and plus it's still got a live case that I'm working on right now. So it's it's getting. But I will definitely. I'm going to ask you to do. Can you take this super chat and after this video put in a comment or even hit me up on Twitter and send it to me because I'll take that. There are a couple of other things that I'm taking care of now, but let me know because I'll definitely take a look at that. Thanks again for the super chat for $5. All right, so let's get back to the document. All right, so So now the lawyer, if you look down here, they have a footnote. It says on July 13th, 2020, Mr. McCrae's counsel filed an affidavit stating that mail addressed to Mr. Curtis at 2435, blah, 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 had been returned as non-deliverable. True, right? Because this address does not exist. Mr. Curtis' street address is this. So Mr. Curtis explained in his in the accompanying affidavit, accompanying this brief, that the previous filings with the court, Mr. Curtis mistakenly stated that the address was 2435 rather than 2543. And she cites Curtis's affidavit. This is merely a typo. The correct address, blah, 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 appeared numerous times within the same filing that contained the typo. So here, if you notice, she's just easily dispensing with the last lawyer's foolery, right? Hey, listen, it was a simple typo. Everything inside here was correct. So, this doesn't make any sense. You know what I'm saying? And it's brilliant because she just dispensed with it in a footnote. Hey, this guy did this whole big thing, but it's easily explainable, and it's obviously a typo. And the funny part about this is that most of Steve's compadres on the other side, what is it, OPT or OTP, whatever, the lawyer that they got over there. He's even saying matter of fact, he went even farther and said that leaving that up there may be what did he say? He said maybe an ethical violation. Now that he knows it, and they say it's a typo. Sean Hufford says it's a typo. So all the people who are following the case on that side obviously agree that that was a typo. So it's dispensed with in an easy way. But again, this is a very professional brief because again, here's the facts. Let's not get into the garbage. So now going further down into the document. It says after Mr. Mcrae obtained a partial default judgment, Mr. Curtis filed a motion to set aside the default judgment, followed by a revised motion. Since that time, Mr. Curtis retained counsel, right? And now the amended motion is followed. So we've gotten a factual, and I believe a very good factual. Boom, boom. Here is the law. Here are the facts as we both, and none of those facts seem to be in dispute, right? Nope, nobody's disputing the facts. Nobody's disputing the facts. The facts are just exactly what she laid out, the same thing that Steve laid out. But now she's going to tell us the law. Now, let's go into her legal arguments because this is where it's either she's going to convince us or she's not. Now, remember, the judge is going. Now, I also want to make it very clear too. She's worked for this judge before, right? For 2 years. How many default judgments or how many times have the service issue come up? And she knows what this judge is looking for. She knows how this judge acts. She knows what to say to this judge. It's funny because when I was at the DA's office, there were judges. There was a judge who used to work with constantly. I knew what the judge liked. I know what the judge didn't like. So when you had a new attorney come in who did stuff that I know the judge didn't like, I would just sit back there and laugh. So this attorney knows, that, hey, we've dealt with this issue before. Do you not think they've dealt with a service or process issue before? So she's writing it very particularly. She's writing for an audience of one, her former boss. And that's what you have to, when you look at this, understand that that's where this is coming from. $5 super chat. Nate, did you let G-Man win at chess? What's your favorite courtroom movie? G-Man, yes. G-Man did win. He beat me in chess once. But that was I was smashed. And I told him, he knows I was super drunk. And I had 5 queens. It was something insane. I had 5 queens. It was just stupid. So yes, that's true. And what's your favorite courtroom movie? I don't know. I have to think about that because I like a lot of them. I like a lot. So I have to check. Let me go back to the documents. But thank you for the $5 super chat. I appreciate it. Thank you, Grammy. And we're working. I'm going to work on civil law. We're going over some of the movie reviews because you said some. I think we're going to start with My Cousin Vinny because that's what you said. You remember you said Pace, My Cousin Vinny. So we're going to be doing My Cousin Vinny for you. So we'll be on the lookout for that. Thanks again for the super chat. Here's one more. I'm from Reed. Thank you for the $5 super chat. Could Kyle's business address be different than his place of residence, and what bearing might that have? Yes, but here. It seems to be the same. Kyle doesn't work. His business address and home address seem to be the same. My business address and home address happen to be the same. So it could, if you can prove that his mom's address was his business address, but there's been no facts to show that that's even been, the judge can't make a ruling based on hypotheticals. It's just what's in front of him. And right now, nobody's alleged that was a business address. They just said Kyle lived there. And the other side is saying, and both sides agree, he did not live there. So that's a great question. But again, if nobody's alleging that, then the judge is not going to consider it, because that is just it just wouldn't be fair, to the judge to say, well, it could have been his business address. No, if nobody's alleging that, then it is what it is. Let's get back to the document. Thank you for the super chats again, guys. So here are the legal arguments. Let's start here. All right. So first, for good cause. Now she starts with a quote of the general statute, right? She starts with, let's just go right to the law. Let's not even start with the BS. For good cause shown, the court may, again, this is a may, set aside an entry for default. And if the judgment by default has been entered, the judge, again, may set it aside in accordance with Rule 60B. Now, that was a rule that we cited earlier. So she hit you with the law. Okay, so this gives you a court authority to set aside it. Rule 60B4 provides that a defendant may be relieved of a default judgment if the judgment is void. Now, same citation. So now she cites that rule, and then she cites prevailing case law. So if you guys want to look at some cases that stand for this proposition, here's the full case citation. You copy this, you paste it, and you can see it, right? So this is saying, this is standing for this proposition that you can be that the defendant may be relieved from a default judgment if the judgment is void. So next sentence. A defect in service is a jurisdictional defect that renders any, and here we go to quotations, any judgment void or other obtained thereby void. And she gives two cases for that, right? It's citation for that. So we know right now, based on North Carolina law, that if you weren't served, it's a jurisdictional issue, right? You didn't obtain jurisdiction over the defendant. And any orders, like an order to show cause, or Steve's his order ordering Kyle to turn everything over, they would be void. Void meaning they have no legal effect if service wasn't proper. And she gives you the case sites for them. So if you want to, look them up, but they're up there. Copy and paste them. If the court, here's Secret Squirrel for $5. Thank you, Secret Squirrel. If the court gets overrun with purple frogs, will it help Kyle's case? Asking for no reason. Thanks, Secret Squirrel. See, I'm flowing well, Secret Squirrel. I love Secret Squirrel. Secret Squirrel knows, but I'm flowing. I got a good energy going on. And you hit me with this, Secret Squirrel. You're throwing me off. But don't worry. I appreciate the $5 super chat. Thanks again, Secret Squirrel. This is crazy, Secret Squirrel. But we're going through it. We're going to get through this today. Okay. So let's continue. So again, remember, it's funny because earlier I think Steve was asking for case citation. So she's giving it to you. Like, here they go. Again, here's some more law. Service of process is defective if it does not meet the requirements of the Rule 4J. Again, here's another court case that stands for this proposition. The provisions for setting aside a default judgment are to be liberally construed to give litigants an opportunity to have a case disposed of on the merits. Now, this is probably one of the more important pieces of this document. This is very, very important. Here we go. LexisNexis is a powerful tool for lawyers. Yes, Dana McWhite. Thank you. I have LexisNexis too. Thank you. Thanks for the $5 super chat. Yes. But again, if you copy these case sites and just put them in Google Scholar would send it to your Google case law. So you don't have anything to worry about that. So what does this mean? Why is this so important? Well, when I read through North Carolina law, and again, this is not legal advice. I am not a North Carolina attorney, but I did read through the law. There's a very, very, very important piece here. The courts, it says, the courts hate default judgments. They hate them. They do not want a default judgment on the books because it is unfair. A default judgment's unfair. It gives the plaintiff whatever they want. So the court would rather judgments to be on the merits, the judge or a jury assessing the evidence and ruling based on that standard, not a default. So this is essentially saying that if everything is tied. If you're here at 50-50, 50% to overturn it, 50% not to, tie goes to overturning it. Tie goes to the runner. So if all things are equal, Kyle should win, and the court should overturn the default judgment based on the principle of fairness, if everything is equal, right? That's what this is saying. So we understand default judgments are important, but we have to understand in this context, if all things are equal, the court is going to favor overturning a default judgment than keeping it. Do we understand that? Now, I think this is important because now this is how the judge has to read this stuff, right? This is how the judge has to understand that tie goes to Kyle if it comes down to this. And here's the case citation. So if anybody asks you for case citations, the court is here it is. Boom. Check this out. Thus, now this next sentence, thus, any doubt should be resolved in favor of setting aside the entry of default judgment. Case citation. 1, 2, 3. She lays it all out. Here they go. So again, thus, any doubt should be resolved in favor of setting aside a default judgment. This is what a professional brief looks like, ladies and gentlemen. So now the court knows tie goes to Kyle. Any doubt should be resolved in favor of setting aside the default judgment. Why? Because the court wants it to be judged on the merits and not on a default. That's what she's given the court, and this is what the judge now has to decide to look at. Tie goes to the runner. Now, this has just made Steve's argument a little more complicated, right? Because now he's fighting a more uphill battle. Great. And here's the law. So now this attorney, one thing I appreciate what she did was, so she goes and says, okay, Your Honor, this is what North Carolina law says, and this is how you should look at this, right? You should look at this in this way to say, if tie goes to Kyle, and here's all the law and stuff that says that if we are tied, everything is saying that you should let this thing, set aside this default judgment. You need to set it aside so we can now have our day in court, right? It's not fair. And here's all the law and stuff to show you it's not fair. $5 super chat from Exiled. If Steve brings in purple tuties, will that help? Yes, it will help. It will help us because it will be funny. Thank you, Exiled. Love you, Exiled. Thank you so much for the five pounds. Actually, I don't know $5, but £5 for my English speaking friends over there across the pond. All right. So now we get into the legal arguments, right? So now she set the stage, which I think is great. Set the stage, Your Honor. This is how any doubt should be resolved in setting aside the default judgment. Now here we go. Here's the legal arguments, right? The partial default judgment is void. That means it's legal. It has no legal effect because Mr. Curtis was not served properly. Proper service is a prerequisite of personal jurisdiction. Now, for most of you who don't know what personal jurisdiction is, the court to render judgment against someone has to have two types of jurisdiction. It has to have both subject matter jurisdiction, which means jurisdiction over the subject matter. If you get in a car crash in New York City, then sometimes, let's say I move to California. California courts generally don't have subject matter jurisdiction over a car accident in New York, right? So that's what you're looking at. You're looking at subject matter jurisdiction. They have jurisdiction over the subject matter. And then they have to also have jurisdiction over the person. So that's what service does. Service gets you jurisdiction over the person. You're being notified that you are going to court. And that's what Kyle's attorney is saying. If you're not served properly, the court doesn't have personal jurisdiction. So the court can't tell you to do anything without personal jurisdiction. That's how important it is. $5 super chat. How long till we hear from the judge's decision? They say a couple of weeks. And they also say that this may be streamed on Zoom. So we may be able to see the court battle, which would be wonderful. I'm definitely going to do a viewing party if they do. So if it's on Zoom, because these should be open to the public. So if they do have a teleconference or a telehearing, we may be able to watch it. So look out for that. Thank you, Marcy M. $5 super chat. Dragnot may want to remind Steve supplicants to watch the entire video I remember the guy before responding and laughing. That's true. That's true. Isn't that what happened with what's his name? Sean. Sean just watched like the first 5 minutes or something like that. And well, hey, mistakes happen. You know what I'm saying? I think a lot of people just are drag not. Hey, if you haven't checked out Drag's channel, you got to check that out. There's some great stuff on there. I watch it all the time, so check it out. This is a good brother right there. Thanks for the $5. Let's go. Let me go back to the thing. So let me put this back on screen. So we are here, and so if you don't have personal jurisdiction, this court has no authority to tell Kyle. So because Mr. Curtis has not been served properly with the complaint in this case, the partial default judgment entered against him is void, and she gives the relevant law under this law. So that she's saying this doesn't even have any effect because he wasn't served properly. Now we go into the rule. Rule 4JC1 of 4J1C contains the requirements for service of process for individuals by registered certified mail, the method that Mr. Mcrae used here. So here she says, okay, so let's go through the law. Rule 4J1C provides that service by certified mail is achieved by mailing a copy of the summons and complaint, registered or certified mail, return receipt requested, addressed to the party to be served, and delivered to the addressee. So this has been, an emphasis has been added to delivered to the addressee. It doesn't say delivered to anybody, right? It doesn't say delivered to the mom. It doesn't say delivered to any adult. It says delivered to the addressee, delivered to Kyle Curtis, right? So here it is. It says, and she gives the law for that with the emphasis added. Where the statute provides for service of summons by designated methods, the specified requirement must be complied with, or there is no valid service. So if it says it has to be delivered to the addressee, the placer's house, if you don't do that, service is invalid. And she gives citations. So again, she's saying, here are the cases. Don't trust me. Go look up the cases. Here they go right here, right? North Carolina cases. Moreover, a person relying on the service of a notice by mail must show strict compliance with the requirement of the statute. Again, more law. Here it is, right? This is not me talking to my ass. This is the court saying these things. Lastly, she says, importantly, although defective service of process may sufficiently give the defending party actual notice of the proceedings. That's what Steve was saying, right? Kyle has actual notice of the proceedings. Such actual notice does not give the court jurisdiction over the party. And she has 3 cases that stand for that proposition. So Steve's whole argument that Kyle knew of the lawsuit, right? She's attacked that directly. The whole thing that Kyle had actual notice of the lawsuit, right? He knew. The law itself says that does not matter. It does not matter. It is a vacuous argument that he knew. It is about whether he was served properly. And that's what this is saying. Defective service may tell you you're being sued, but that has nothing to do whether you now are legally responsible to respond to that lawsuit, because service is such a technical issue. Crazy, huh? Crazy. So the lawyer made sure, and look how long this site is. Case 1, case 2, case 3. She's just made sure, like, it is this is not even a question, right? This is not even a question. And here's all the cases. She gets the 4 or 5 cases here that stand for that proposition. And go look at it. Go look these cases up. This is a lawyer who's done the research and now is telling you this is what the law is in North Carolina. $10 super chat from Learning with Suge. Appreciate the stream, Nate. Have a good day. You too, Suge. Haven't seen you around in a while, but I'm glad to see you here today, brother. Thank you so much for the super chat. So here we are going here. Let me make sure we're good here. Yes. All right. So here, Mr. Mcrae attempted to serve Mr. Curtis by certified mail at the residence of Mr. Curtis's mother, right, on August 30th. Mr. Curtis, however, was living in Charlotte, right, on that date. To be sure. So now the lawyer's saying, well, hell, to be sure, right? So there's no doubt that this is true. Mr. Curtis' affidavit, a lease attached to Mrs. Curtis' affidavit shows that beginning July 15th, he had moved. He lived at this other address in Charlotte. Moreover, he has financial statements, and even his tax form from 2019 reflect Mr. Curtis's residence in Charlotte, North Carolina. He has been there since July 2019. See, all the affidavits. We have plenty of evidence that he lived there. In sum, Mr. Mcrae's attempted service of the summons and complaint to an old address was procedurally defective. That defect is a jurisdictional one that renders the partial judgment against Mr. Curtis void. Accordingly, Mr. Curtis requests that the entry for default and default judgment be set aside. Conclusion: for the reasons stated in the brief, defendant Kyle Curtis respectfully moves to the court, asking the court to set aside the default judgment based on these rules. Signed, Scotty Forbes Lee, attorney at law, counsel for Kyle Curtis, and certificate of service. She electronically filed it. And here is certificate of service. Yep, to the business court. All right. So Kyle's attorney said, yo, here we go. Here it is. It's all done. All right. We got it. So what do you think? Do you think she answered all the questions that Steve and his fans have been saying? Number one, actual notice doesn't matter. So defective service, if he had actual notice, it doesn't matter, because defective service it doesn't matter if you actually knew about the lawsuit. It matters whether you were served properly or not. Number two, it was sent to an old address. That's not good enough under North Carolina law, because it wasn't even sent to the addressee. It was sent to his mom. Both sides are saying that. Steve's side is saying that. And the kicker here is all of the issues that Steve's counsel brought up before, the fact that that the affidavits that Kyle got weren't notarized, fixed, right? It's notarized. The lease agreement, all this other evidence. And remember, Steve's attorney's main argument, let's look at it again. Their main argument was that Kyle had actual notice of the lawsuit. That was the crux of their argument. If you don't believe me, let's look at it again. Steve's lawyer's argument was, let me look at C. So this is Steve's motion in response to the motion set aside. So this is Steve's lawyer writing, and it was C. Let me just go back here to C. Where's that? C. This is A, B, and C. Where's C? Here it is. The defendant had actual notice of the lawsuit, right? So Steve's saying the defendant had actual notice of the lawsuit and has failed to rebut the presumption, right? So she's out. So Kyle's attorney answers that question directly. Yeah, he had actual notice, but, right? She says, yeah, he had actual notice, but that's not good enough. And here are the cases that say that, right? Here are the cases. She literally puts the cases, and she puts a whole bunch of them just to make sure, like, hey, this is it. Let's look at it. She puts the cases. Let me find it. Actual notice. Here it is. Importantly, she responds to that directly. Importantly, although defective service of process may sufficiently give the defending party actual notice of the proceedings. So she's saying, yeah, he's right. Right? She's right. He had actual notice. It doesn't matter. But that doesn't matter. Because the law says such actual notice does not give the court jurisdiction of the party. Citation. Right? And here's all the cases that also say that. From the appeals court, here they go. So that's where we're at. And it seems like, that was it. And again, look at it. There's no BS here. There's no fluff. This is just boom, boom, boom. Here's the law. Here's the standard. And here you go. This has to be set aside. And matter of fact, if you are sitting if you're sitting there saying, I don't know, it's 50-50, the law says you should set it aside anyway because it's not fair. The law says that. From Jeff Swartz, will Steve block the judge from being dishonorable if he finds in favor of Kyle? I don't know. It'll be interesting. I don't know. Maybe he will. And remind you, and let's just be honest, people. This attorney, Steve's attorney was hanging his hat on this actual notice thing. And this lawyer just destroyed that. Steve's attorney was hanging their hat on the fact that this was hearsay evidence. That's been resolved. So what's Steve's argument now? He can't go around and say, well, he had actual notice of the suit. We even have a recording of him saying that he was served, right? He was served. None of that matters. Matter of fact, think about how bad it might be, because this lawyer didn't even go to the part where Steve has been saying that Kyle was served, right? She didn't even go into that. The fact that Steve has been saying all this time that he sent it to Kyle's old address, right? She didn't even mention that at all. Why? Because it's unnecessary. We know for a fact he didn't live there. This is what the law is. The fact that Steve said is a bonus in case they have to come in and testify. But for what reason? It's all over, right? It is here. It's done. Now if Steve wants to get in the stand, what do you think her first question to Steve is going to be? Did you know he lived there? Did you know he had moved? And then if he says no, you start playing the recording. So when you said it this time, 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 when you said it the 5 or 6 times you said it, were you lying then or are you lying now? He didn't live there. Steve knew it. It just is what it is. So now I got a thought to you. What do you guys think? Do you guys think who do you think has the better chance here? Now, Steve's and his attorneys may respond to this. I'm not sure. But who do you think has a better chance? Do you think Steve has a better chance? Or do you think Kyle has a better chance to get it set aside? Not now knowing what the law is. Now knowing what happens. I don't know. If you're asking me, what percentage would I put? Now, and Lord, you can never say 100% this, 100% this. But I would say, if this is all we have, right, and besides some other legal something that could pop up, which I'm just not unaware of, if this is all we have, these two things and this understanding, it seems like Kyle's in a pretty good spot. But, I would still put it maybe at a 70-30. 70% that Kyle will get it thrown out, and 30% that Steve holds on. Because there's a lot that's going on here. So let me see if any more questions for me. Let me go through this. Here we go. Kent Hovind, CPA. Thank you. And remember, I need you to do my taxes. Mcrae cried so much, I'm now rooting for cocaine Kyle. Thanks for the super chat. Hovind, CPA. My first question would be, why do you smell like K-food, Mr. Mcrae? Because of lobster rolls, that's why. Lobster rolls. This is crazy. So you now know what the law is. We now know what both sides' arguments are. And have you been convinced? So let's just take a straw poll chat. Who do you think? Do you think this default judgment is going to be set aside? 1 for yes, 2 for no. There's 300 of you out there. Let's see what the poll says. I'll actually even throw a poll up on Twitter. I am going to say this, though. I think Kyle's attorney is amazing. Like this was no game. Like she put it together. This was really good stuff. This was really, really good stuff. Like she made sure that we are making this happen full show, right? So his attorney is really, really, really made this happen. Made this happen. This is really good. This is just really good pleading. The best argument comes from Steve himself when he says he knew that Kyle didn't live there. Not sure how Steve subsequent squared this one. Yeah. Oh, we got a 2 here. Nice. 60-40. Nice. All right. So it seems like most people are 666 deal non-cog. You contrarian pineapple. Yeah, I honestly think I'm typing a 1 too because I really think it's just it is what it is. You know what I'm saying? It just is what it is. You have to you just look at both of them. Steve's lawyer seemed not to have any legal argument to really say that it's actual notice thing, and Kyle's lawyer seems to just destroy it, just undercut all of that shit. Here it is. You know, they're all talking BS. Let me get into Kyle's lawyer was like an adult walking into the room. Yeah. Now, it's funny because when you're on Twitter, everybody keeps saying, what's the case law? What's the case law? It seems there's the case law right there. Thank you for the $5 secret squirrel. Yeah, where's the evidence? The evidence is right there. It's literally right there. Go check it out for yourself, right? Here's the case law. Don't trust me. And that's one great thing. And that's what I keep saying about this case. When you have the law on your side, you argue the law. Kyle's attorney has the law on her side. When you have the facts on your side, you argue the facts. Steve's attorney has the facts. And the facts in this, so, you know, at this particular point in the day, are the facts going to overcome the law? Who knows? It's just going to be tough. It seems like the proceedings are more difficult than picking up old balloons, if you know what that means. I do not, but you have to tell me. I do not know what that means. But maybe pick up old because they pop. Thanks for the $5 super chat. I got now you're gonna make me go all this thing because I'm gonna be thinking about it all day. Peter, too. You think Steve still got a chance? It's interesting. But I can see it going both ways. I can see it going both ways. But we'll see. I really think we're talking about like 70-30 for Kyle. I was at 50-50 before. Then I moved a little bit more over, but I'm more 70-30. I think Kyle has when you have the law on your side, it's going to be hard. And the fact that the presumption that the court's system is presumed to want to overturn defaults, it's you got a lot here. I don't know where Steve is going to go from here. $1.99. Got a jet. We'll watch replay. Happy hump day. You too. Thank you, Roddick. Thank you. Happy hump day to you. I'm about to get out of here. Let me answer a couple of last questions. Here we go. Hellsoy. How about a copyright lawyer to talk about the eventuals if the copyright issues, if any, copyright issues, if the default judgment gets set aside, and now it's about the money. You know what? Yeah, I'll see because I know Leonard French. I might speak to him and ask him about the copyright issues because it's just not for me. So you know what? I'll ask Frenchie and see what he thinks because I think the copyright issues are it's an interesting thing and it's a different type of law. But he does it all the time, so he may know. Progressive liberal. Nate the lawyer. Steve says the judge does not find this motion impressive. I'm not sure he knows that. I don't know either. He can say whatever, but this is impressive because don't forget it answered all of his questions. So, all right, guys. Well, look out for my next video. It's going to be again the video I'm doing next is about the Cardi B case because she was trying to get her case thrown out because she said that the state didn't give her a speedy trial under both the federal constitution and under the state constitution. So that's going to be an interesting case. So we'll look at that. Also, I'm doing a couple more things, non-sex stuff. When it comes up, I will be taking care of it. Tony Montana hit me with $1.43 for my toothbrush. Thank you. Toothbrush appreciates it. Thank you for the $100. I do not know where this is from, but I appreciate it. If it turns out to be $1.34, I appreciate the $1.34. YouTube will take the 34 cents though, so just to let you know. So listen, guys, I hope this was informative. I hope you guys enjoyed this. Thank you for spending some time with me today. And the next time I'll see you, hopefully will be after the judge's ruling. Hopefully it'll be up so we can all see it. If it is, I'm going to go live and I'll watch it live and we'll be commenting on it too. So thank you for everybody who showed up today, and thank you for all the super chats. Thank you to my members and thank you to my Patreons. Really appreciate you and appreciate you supporting the channel. So with all that said, my name is Nate, lawyer, YouTuber. You know who I am. You know what I do. Hopefully this was informative, and I am